We begin at birth. An infant is the descendant of an estate or grantor, owner or trustor of a trust, guardianship, receivership, or custodianship that has yet to receive an SSN. An infant is anyone under the age of 21. Your mother allegedly abandoned you at birth. Have you noticed the mother's address is already pre-typed in one of the boxes? Have you noticed there is no address for the father on the certification of live birth? Have you noticed it is the address of the mother's maiden, unmarried name in that box? And have you noticed that they had the mother sign as the informant and not the father? You are considered an infant, ward of the state. As your mother, as the informant, a person who informs on another person to the authority, signed your record of live birth, allegedly acting as the trustee of the executor's father's estate. If she declared she was married, then the father and mother are one in law, and thus the mother would have the same authority as the father, executor. However, as an unmarried woman, they assume she is acting as the co-executor of the estate, or in the capacity of a trustee, one with authority to sign over property. However, she has none without her husband's approval in a common law marriage. In a civil marriage, she has no authority. We must also note that the line of executor would fall on the nearest male relative. Not only is the mother without legal representation, no male is listed either. In fact, all male relationships are left off the documentation. There is absolutely no reason for the father not to be on a birth record, except for religion. Matthew 23:9. And call no man your father on the earth, for one is your father, even he who is in heaven. The First Amendment clearly prevents the government from adding his name, prohibits the making of any law respecting an establishment of religion or impeding the free exercise of religion. Thus, the term father would impede the establishment of religion. Some states' instructions on completing the birth certificate, quote, signature of parent, have parent review the certificate of live birth for accuracy. Read the statement contained in this section and sign this section certifying the accuracy of the certificate. We suggest that you ask only the mother to sign the birth certificate. Never have a parent sign a blank or incomplete certificate, quote. Now, why would the Department of Health and Vital Statistics teach doctors, nurses, and hospital administrators to coerce the mother into signing the certificate of live birth instead of the father, who is the executor of the estate? Because the executor is the highest office of the estate, and the state does not care to deal with him. They would rather go after the informant/trustee instead. Attempting to administrate an estate without written authorized consent of the executor is very costly. People go to prison. But if they can coerce the mother, informant, trustee to sign over the property, then they appear to have a legal leg to stand on. However, it is all based in fraud. Keep as many people as you can ignorant, then you can have the blind leading the blind. Explaining the executor's office and the certificate of live birth. Note, an estate must come before a trust. The state issued the child a certificate of deceased. The grantor, via footprints, created the office for the new estate, the legal fiction, corporate you, in which they were the witnesses of 1. The woman is her own estate in which she is the executrix if she has reached legal age. If not, her father is the executor of her estate until that time. 2. The man is his own estate in which he is the executor once he comes of legal age or marries. Until then, his father is the executor of his estate. 3. When they get married, her estate becomes one with his. If it is civil marriage, then they both have contracted with the state, not joined in a spiritual union with God, but two people cohabiting with the blessings of the state. 4. The woman's estate now becomes property of the man in a common law marriage. In a civil union marriage license, the man controls the property. 5. The two of them come together and have a child. The child is property of the state due to the marriage license. However, the grantor created the office for the executor's use via feet prints. Nonetheless, the executor's estate is abandoned until he or she reaches legal age. Of course, unless the father or mother comprehends this stuff, as neither the mother nor the father is ever made aware of this fact. 6. The state coerces the mother into signing the record of live birth as the informant. presumably acting as the trustee. 7. By doing this, acting as the trustee of the executor's estate, the father, and giving the child to the state, ultimately abandoning the child. The child, you, are the estate. 8. The state runs an ad in the local paper announcing the birth and abandonment of the child. They leave out the abandonment wording, of course. That was the public notice and due process of law. 9. Fraud. Fraud is odious and not to be presumed. Thus, we must presume this is a valid contract unless you can prove these points. When the contract is fraudulent, it is void. For fraud vitiates everything, as to seizes when a condition consists of several parts and some are lawful and others are not. The whole thing is fraud. Unless there is severability clause, then only that part is to be singled out. 10. The executor, father, never shows up to claim his abandoned property, so the state takes control. We must make note, I've never seen the record of live birth, only that of the certificate of live birth. And the COLB has the father's name on it, or someone else presumed to be the father, or no one named as father. Nonetheless, no one claims the abandoned property. Executor or executrix, thus leaving the state or others to control the property. Now the infinite becomes a ward of the state. 11. The doctor sends the record of live birth to the state health department and vital statistics. The state sends the record of live birth to the registrar's office, where a new state's will is recognized and now placed in probate. Note, will is desire, initiating action, having intentions to make things happen. The executor is to carry out the will of the grantor. The grantor being you, feetprints/landmarks, the estate being you, the office created by the grantor, you, for the occupant, you, to carry out the will of the testator, you, for the one who is deceased, you. 12. They split the title and create what's known as the certificate of live birth and send that newly created office to the child in the mail. It's his or her new identity. And when the child reaches legal age, he can now become the occupant of the executor's office of that newly created estate, but is never made aware of this. Fraud. Concealment of a material fact to induce another to act to his or her detriment. Note, the state cannot do business with or enter into contracts with a living, breathing human being. This is why they created the certificate of live birth, making you appear to be a fictitious entity. They had to turn you into a corporation so they could control you by way of contracts using trust, estate, and probate law. 13. Now the child grows up and remains an incompetent ward of the state because he or she never steps up and assumes their proper roles as the executor/executrix of their own estate once they reach legal age. 14. The now adult uses this certification of live birth as their sole source of identity, even though the state advised not to use it as identity. Can you say incompetent? Just as they say to not use the social security card as identity. 15. Oddly enough, the same government that says not to use the certification of live birth demands that we do not use the certification of live birth in order to get permission to do things, like a driver's license, work, getting a bank account, etc. Permission from our guardians as we are treated as incompetent adult, aka ward of the state. 16. Now the adult incompetent is masquerading around town using this certificate of live birth as identity to get into other adhesion contracts and basically acting as an agent of the foreign corporation known as Australia. 17. Presumed to be an Australian citizen is now obliged to pay an income tax, a property tax, and ultimately be subject to the state. Now you are obliged to abide by their statutes, rules, and regulations. Note, they are presuming you're an employee of their corporation, but if you are not receiving a paycheck, and there was no employment contract and they cannot provide proof of pay, then what do they have? Do you work for free? Can they compel you to work for free? That certificate of live birth is an office. You are the occupant of that office. And as that occupant of that office, should not you be paid for your services? 18. Without taking a hold of the office as the occupant, you have lost the inherent rights and have been granted rights and privileges instead. You are a tenement to your own estate, like being a renter to your own home and have to pay someone else for the privilege to live on your own land. The father never showed up to claim his property, and the state took it upon themselves to presume the child is theirs to control, take it in as their own. The child is now considered a ward of the state, an incompetent bastard child with no father, and the mother abandoned him or her. The certificate of live birth has a state seal and registrar's signature, which is certifiable proof that the estate is in or has been in probate. The registrar is the court of probate, and probate deals with estates of the deceased, one who is in the act of dying. To the courts, we are dead, missing in action, legal fictitious entities, wards of the state, bastard children, orphans, essentially infant, which means unable to speak. They do not wish to deal with us directly. This is why they want an attorney to speak to them. The bar attorney has a superseding oath to the bar, aka British Accreditation Registry. Their first loyalty is to the court. They are there to lead the sheep to their slaughterer. And the undertaker in the black robe, the judge is administrating the account of the incompetent, and his main objective is to make revenue for the state, which is acting as the beneficiary of the estate. And you and I are being put into the trustee position of our own estates. Now you understand why the Lord said, "Woe unto ye lawyers." Bar attorneys' first allegiance is to the crown, not you. They are there to make you believe someone is fighting for you. But the truth of the matter is, they are there to help the presumed administrator of your estate. The bar attorney wearing the black robe undertaker make as much money as possible for the court, him or herself, and the state. You are a ward of the state, an imbecile, a menace to society, an incompetent, essentially unable to speak intelligently, an infant, and that is the truth. Take it as you will. Note, I am not saying all attorneys are scumbags. They are intentionally trying to harm you. Some of them know what they are doing, and some of them probably truly believe they are doing the best they can to help their clients. But it is all about the estate, it is all about the money, and it is about your slavery and unjustly enriching the state in the end. It is a constructive fraud upon you from birth, and that is my heartfelt opinion. Take it as you will. Therefore, claim your rightful inheritance. Claim to be living, or better yet, the executor of the estate. You have come to clean up the mess of the trustees and those who are acting without you giving them authority, i.e., warrant. Definitions. Revisionnaire. A person who possesses the reversion to a property or privilege. Reversion. The right of the original owner of their heirs to possess or succeed to property on the death of the present possessor or at the end of a lease. A property to which someone has such a right. The right of succession to an office or post after the death or retirement of the holder. Sestuiq. The person for whose use the fiefment was made. Fiefment, or enfiefment, in English law was a transfer of land or property that gave the new holder the right to sell it as well as the right to pass it on to his heirs as an inheritance. It was total relinquishment and transfer of all rights of ownership of an estate in land from one individual to another. Recitals. The part of a legal document that explains the purpose of the deed and gives factual information. Revert. Of property. Return or pass to the original owner by reversion. Tenement. A piece of land held by an owner. Law. Any kind of permanent property, example, lands or rents, held from a superior. Warrant. A document issued by a legal or government official authorizing to carry out some action relating to the administration of justice. To justify, vindicate, call for, sanction, validate, permit, authorize, deserve, excuse, account for, legitimize, support, license, approve of, merit, qualify for, rate, be worthy of, be deserving of. To guarantee, affirm, swear, promise, vow, pledge, undertake, state, assert, declare, profess, attest, vouch, testify, bear witness, formal aver. Sestuiq Act 1666 made us all dead at birth to protect our property. Thus, if you abandon the estate, cast beyond the sea, lost at sea, dead to the world, and if one day we were ever to return from sea and announce that we are alive, we can take our lawful place as executors of our own estates. During this time, more ships, more travel by sea, and more people leaving a country for the new world to never return.